Mr. Hill, good morning.
Good morning. May it please the Court, my name is Dan Hill. I represent the appellant's town of Wrentham.
This is the same thing, isn't it?
It's a very similar case, Your Honor.
But you actually did,
You
you went to the Housing Appeals Committee.
That's correct. We're in a little bit of a different procedural posture in that we do have a live controversy. We were at the Housing Appeals Committee, but let me just state for the background, it was almost 3 years ago to the date that the Wrentham Zoning Board denied a comprehensive permit under Chapter 40B. The grounds were that the town believed that it had reached that 10% threshold. The issue here is how affordable housing is defined. And the reason the town thought that it reached the threshold was because the regulatory definition of affordable housing includes housing housing subsidized by the federal, state, or local government that provides housing, long-term housing, for mentally ill individuals and families owned and operated by the Department of Mental Retardation. The town of Wrentham has a facility with 300 units of housing owned and operated by the Department of Mental Retardation. It's one of the so-called former state schools. It's called the Wrentham Developmental Center. There's 5 or 6 of these across the Commonwealth. It's not just Wrentham we're talking about in this case. So on that basis, the town felt, gee, what we have here for DMR housing looks just like what the regulation says affordable housing includes. So on that basis, it denied the project right away, did exactly what you suggested, Your Honor, denied the project right away, went to the Housing Appeals Committee. Housing Appeals Committee ruled on the threshold issue of jurisdiction that the town had not reached the 10% on the basis that this definition of affordable housing does not include the DMR housing, although the regulation seems to imply that it would. Your Honor, the issue here is regulatory interpretation. I know we're here on a procedural issue, but what's at stake is the rewriting, essentially, of a regulation by a state agency, which is arbitrary.
That's the substance, but the problem is at the moment, the appeals court says you got to go back, right?
Right.
Don't you really have to deal with that first?
You're right, Your Honor, and the issue, unfortunately, the appeals court did not recognize several applicable exceptions to the final order doctrine, and that's the legal issue here, is the applicability of the final order doctrine or the exhaustion doctrine, and there's an exception that's directly on point, and that's right out of the case of Cliff House Nursing Home versus Rate Setting Commission, which Your Honor was attorney for the plaintiff. In that
Not
case,
not the plaintiff. Let's be clear. The Rate Setting Commission.
The commission, the Rate Setting Commission. In that case, there was a dispute between the Rate Setting Commission and the Division of Hearing Officers. It was basically a turf war over who had the final say in rate reimbursement decisions for nursing homes. And the commission made one decision, then the division made another decision, and then the commission appealed that to the Superior Court. The Superior Court said division has supremacy. The commission then wanted to appeal that further, and the division said no, that was a remand order. The Superior Court remanded that back to the commission for further proceedings. But the commission said, we don't have any other way to get a judicial remedy or a review of this decision of who has supremacy if we don't take the appeal now. And this court recognized that exception to the exhaustion doctrine, that the commission could not have appealed from its own remand decision. The same is true here. If this case is remanded back to the zoning board doesn't have the ability to remand from its own decision. The only way this could come back to this court or the Superior Court is if the developer appealed from that remand decision and appealed to the Housing Appeals Committee, and then the Housing Appeals Committee issued a decision that the developer didn't agree with, and then we're back here. But those are two assumptions that may not occur and are completely outside of the control of the zoning board.
Plus, you really have a time issue, right? I mean, in other words, if you need to go back and have a comprehensive hearing, I mean, just looking at these 6 cases that we have, these time periods that process takes are not inconsiderable. I mean,
The time periods at the local level?
At the local level,
Yes.
then the Housing
Quite
Appeals
true.
Committee level, and then finally on appeal. So we're talking
Years.
Well,
right?
and that goes to my point, Your Honor, that it's sort of ironic that the Housing Appeals Committee is arguing that by filing that this will result in floodgates of litigation, and this will delay the construction of housing, when in fact what the town is seeking is an immediate adjudication on this narrow legal issue which, 3 years ago, this could have been resolved. And instead we're here 3 years later to the detriment of not only the town, but the poor developer. The developer has been sitting around for 3 years not knowing what's going to happen with his application. So
Care to estimate what the increase in the cost of developing the project would be?
I cannot, Your Honor.
Care
but
to
certainly-
estimate what the margin of profit is when you're doing affordable housing? Care to estimate what the need for affordable housing in this Commonwealth is? Aren't we trying to get expedited proceedings? Isn't that the whole purpose of the statutory scheme?
Exactly, Your Honor. I couldn't agree more, and for that reason, this exception should apply. It's judicial economy. It's economy for everybody to allow a town to get an immediate adjudication on this issue. Ideally, there should be a regulation that provides for towns to get that kind of determination from Housing Appeals Committee or from DHCD, and then set up an appeal process. But that doesn't exist today. And until it does, this is our only route of recourse, is to get some sort of decision from the HAC and to take that on appeal if it feels that there is a meritorious argument. Your Honor,
Mr. Hill, let me
Sure.
just, are you asking, I appreciate that's the issue, but were you implying that we should also resolve the issue on the merits? That is
No.
whether, okay.
no, Your Honor, you could. I mean, I think the record is clear enough. The Housing Appeals Committee did make a decision on the merits, and that is in the record. The issue is, what kind of housing is DMR? Is this Wrentham Developmental Center? Is it the kind of housing that's envisioned by the regulation? The housing is long-term housing, and the history of this is that these former state schools, a lot of them were shut down in the 1980s, but some of them weren't, and the reason is because a lot of folks, it was more appropriate for them to stay in these facilities rather than going into group homes around the Commonwealth. And for that reason, this school, as well as other facilities around the state, have stayed open. There is no functional difference between what's provided in Wrentham and what's provided in group homes across the Commonwealth. So you could decide the issue, and that probably would expedite things. Going back to the construction of the statute argument, the purpose of 40B is to expedite the construction of affordable housing. We feel that by having to go back to the Housing Appeals Committee, going back to the zoning board on remand, that'll just further delay.
So what the town
adjudication.
is saying here, in essence, is we know even if we feel we've met our 10%, we're not going to exercise our discretion to consider this project.
Not this one.
Not this one. But, Your Honor, the town has approved 2 other projects since the time
But
that
I
it denied
said,
this
they're
one.
not going to approve this project.
It didn't
We
feel.
don't want this. And the committee is basically saying, well, why don't you take a look at it and hear what everybody's got to say?
Right.
And then we'll settle the 10% later, ultimately in the Superior Court and the appellate courts.
Right. The town would say that is a very inefficient way of doing things.
Could you tell me, in the other 2 cases in which the town has approved projects, did they use the DMH facility as a basis for establishing their quota?
Yes. The board, in its decisions, made a finding of fact that it had reached the 10%, but notwithstanding that, they were going to issue a comprehensive permit for those projects.
Mr.
Which
Hill,
they're
if you-
entitled to do, which the
Right.
town is
Under
entitled to.
Boothroyd, they're entitled to do that, and they did that.
If you take the units from the other 2 projects, and you backed out these ones, do you get to 10%?
No. No,
And
this
that's
project
an
is,
issue that we have on tomorrow, if you'd care to come back tomorrow.
right. This development has 300 units. That is, the other projects had 25 and 4 units. So this project
looking
makes a big difference.
Looking at it from the town's point of view, and I'm not going to ask you to comment on the earlier case because that would be somewhat unfair, but looking at it from the town's point of view, the town may say, look, we've got some we're not opposed to affordable housing, we're not opposed to comprehensive zoning permits, and there might be, a minimal impact size building where somebody wants to do that, and we're just as happy to facilitate that. But we don't want to get engaged in these 300 or 600 or 1,100, I forget what Linden Pond was, 1,500 unit projects under a comprehensive zoning permit scheme, unless we know we have to. If we have to, fine, that's okay. But if we don't have to, why do we have to get engaged in that, from the beginning?
Yeah, that's the point, Your Honor. It's an efficiency issue, and I think that what perhaps, I think in the last, I was here for the last argument, and I think what's unfortunate is that the role of the town seems to be kind of misframed here. The zoning board is not a party, technically. It's not a party in interest. It's a quasi-judicial entity that's supposed to be entertaining neutrally these applications. It's not supposed to be taking positions right out of the box. And I think that's, it's important to remember that a town is not going to say, here's an application, we don't like it, let's deny it on this ground. The zoning board really should be entertaining it for its merits, but it should know up front what the standard is that's going to be applied. And that's really the issue. The zoning board, without knowing whether or not we've reached the 10%, has no idea what standard to apply. The standards, as you probably all well know, the standards are completely different when a town reaches the 10% than it is when they haven't. So it's really a function of, just like the rate setting commission, not knowing what the rules of the game are. Do we have the supremacy? Do we have the right to deny this project, or do we not?
Or you do have the right to deny a comprehensive zoning permit, as opposed to asking the developer to go through the series of permits that it might be required from the town.
That's correct. I think I've covered my arguments, Your Honors.
We would be delighted if you ceded your time.
Might actually leave early.
We think you're a brilliant oral advocate.
Thank you.
Thank you, Mr. Hill. Ms. Weiss, see if you can top that one, Ms. Weiss.
Quite a challenge. Thank you. Good morning, and may it please the Court. Juliana Rice, Assistant Attorney General
You will
for
not be surprised by my first question.
the Housing Appeals Committee.
Why? I mean, the name of the game here is expedition.
Absolutely, Your Honor.
So why don't we just decide the issue as to whether the 10% does or doesn't apply here?
There are two reasons, Your Honor. In hindsight, of course, if the town wins, of course, it would be more efficient to have decided
Or
it.
loses.
And no, Your Honor, I'll disagree with you there. And the reason is that if the town goes all the way up through the appeals court, through this court, and loses, then they have to go back to square one. The developer has to present the project all over again, and the town then engages in substantive consideration. The statute very specifically requires that that substantive consideration has to occur at the same time that the town makes its deliberation on the 10% or any of the other statutory minima. That breaks the tie, Your Honor. If one in hindsight could speculate as to, in a particular case, whether allowing immediate judicial review of a standalone issue may or may not be efficient, these courts have decided that, as a general rule, piecemeal litigation is not efficient and have carved out specific exceptions to that rule, and the appeals court correctly determined that this case does not fall within it.
Well, isn't your, I'm sorry.
Go ahead.
Isn't your argument, I thought you were saying, is that it's quite apart from what case law, administrative law, case law says, you're saying the language in Section 23, is it?
Section 20, Your Honor.
Section 20, about denial after comprehensive hearing?
Correct.
That language
Correct.
governs here.
Correct, Your Honor. As this court concluded in Boothroyd just last June, the ZBA must deliberate about whether to impose or override its own local requirements, even if the town has met the 10%. The remand here was intended to allow for such deliberation, nothing more. That is a plain reading of the definition of consistent with local needs set forth in Section 20, the definition section.
Because a lot of things could happen. The town might listen to the developer and say, well, okay, this is worth it, and change their mind. Or they might say, well, 300 units, no, but we'll give you 250. And he might say that, or it might say that's fine. Awful lot of things could happen.
Yes, Your Honor, that's exactly why the town is supposed to be struggling with the issues that all towns, the very complex issues that all towns are required to consider, balancing their environmental needs, their open space needs, their safety needs, with what's widely acknowledged and has been held by the legislature and this court to be a pressing need for affordable housing.
But the HAC has already ruled that they have not met 10%.
That's correct, Your Honor.
And we acknowledge that the 10% standard makes a huge difference in what the town can and can't do.
I disagree with that, Your Honor, and I disagree specifically with Attorney Hill's representation that there are two different standards and the town needs to know which one to apply. In fact, as this court held...
Well, if they've met 10%, there's a presumption that local needs are met.
That's correct.
By the fact that they've reached 10%, period.
That's correct, Your Honor. However, the town is still required under Section 20 to impose those local requirements after considering whether those requirements are reasonable in view of the regional need for affordable housing. That's what this court held in Boothroyd.
But the standards are still different, so wouldn't it be helpful to know?
I disagree, Your Honor, that the standards are different. Attainment of the 10% statutory minima, or either of the other two, does not extinguish the applicability of Chapter 40B in any
that's
city
clear.
or town. All it does is change its application. So certainly, achievement of the 10% or any of the other statutory minima will shield the town's denial of a comprehensive permit application from committee review. However, it does not relieve the town of the obligation to consider the substance of every qualifying permit that is put before it.
I listen to your argument, but I have to say in the real world out there, it makes a fairly big difference. Because on the one, I mean, again, you have to think of what the scope of these projects are. It may not make a big difference in a relatively small project, and there are lots of wonderful 40B projects that are, you know, small little buildings that would convert it. But there are also big projects that are online, and it makes a fairly big difference if the town is not at the 10% mark.
I disagree, Your Honor, because the conduct that Chapter 40B is designed to stimulate at the local level is serious, thorough, and speedy consideration of the merits of any proposed project that is brought before that city or town. This court affirmed that in Boothroyd last term.
I understand that, but towns for a very long period of time had their own ways of getting multiple permits and so on and so forth, right?
I don't think I understand the question.
comprehensive zoning permit process dramatically changed how towns were going about doing their business.
It did, Your Honor.
Furthermore, there could be some finagling in the towns and cities in this sense. They've got 3 applications before them, 25 units, 25 units, 50 units, and then this 300 application simultaneously comes in. And they say, well, let's do the smaller ones, get our 10%, and forget about this big one. We don't want it here. And until it's thoroughly vetted, really, we can't assess that.
Well, there are timing requirements
Or
under
they could
section.
reverse that and say, we'll do the 300 and knock these other ones out.
The town could do that depending on when the relative filing dates were. There are time requirements under Section 21 of Chapter 40B requiring a public hearing at the town level to open in a particular time and requiring a decision to issue within a particular time. So,
Can I ask you this, that you, what you're saying is the town erred because it didn't have a comprehensive hearing.
correct.
So, when HAC sent it back, let's assume now they have a comprehensive hearing, and they deny the project. Can they deny it based on the fact that the town has met the 10%?
The town can do that.
So that's not a finally decided issue by HAC?
No, Your Honor, it isn't at this point, because remand orders, as a general rule, are not considered final orders for purposes of application of the final order doctrine.
So, for HAC's perspective, if the town comes back and say, okay, we've had a comprehensive hearing, and the town has met its 10%, and therefore we are rejecting this, HAC is not going to say, already ruled on that. That's res judicata issue already resolved. You can't do that.
No, Your Honor, as the appeals court made clear, the town has many options open to it in implementing the remand order. The HAC did not seek to.
And I'm asking you how, if the town does what I just suggested, what will HAC's response be? Will it be that we've already decided that issue, or will it be something else?
It may well be that HAC would go forward if the town denied the comprehensive permit after holding a comprehensive hearing, and the developer appealed to the Housing Appeals Committee. The Housing Appeals Committee, having already decided the 10% issue, unless additional evidence were put forward or other claims were made, would decide the denial, would review the denial for consistency of local needs, and all of those issues, including the 10% issue, could go up at the same time, as is the general rule.
Could the
Ms. Rice,
developer, well, go ahead.
If the town does, as Justice Corey is saying, and the second time around says, you know, we had the comprehensive hearing, but we're gonna hold on to our view that we've met the 10%, and that's the reason we're denying it. By the time you get judicial review of that, you will have spent 3 or 4 years, whereas you could have had it 2 years ago.
Your Honor, and again, I'll say that the specific language in Chapter 40B, Section 20, makes clear that you're supposed to have judicial review of everything at once. Everything is supposed to occur at once. The conduct that the statute is designed to stimulate is consideration of the merits of projects early, review of the entire decision quickly.
Ms.
And that,
Weiss, could you just, excuse me, point me to the specific language in which you're relying on Section 20?
yes, Your Honor. In the definition of consistent with local needs in Section 20, the standards that the town is supposed to impose are set forth. The second sentence states, requirements or regulations shall be consistent with local needs when imposed by a zoning board of appeals after comprehensive hearing in a city or town where, and then it goes on to describe the 3 statutory minimum. This court found in Boothroyd that that language, after comprehensive hearing, was not surplus and should not be ignored, and that, in fact, it goes hand in hand with the town's consideration of whether it's met one of the statutory minimum.
Could out of curiosity, if it goes back, and could the developer dispute in front of the board, local board, that the 10% hasn't been met?
The developer could, but it would not waive that issue by waiting to the committee level to raise it.
I realize that, but, you know, he's got the committee's already made this declaration or statement, whatever it is. The developer could say, I agree with the committee, rely on that, or he could put in additional evidence or
At the
data
committee
that the
level-
10% hasn't been met.
Absolutely, Your Honor. And this record is woefully thin on the factual pertinences surrounding the Wrentham Developmental Center.
Ms. Weiss, it goes back for a comprehensive hearing. And what if the town, then the town, I assume the committee's position is they have to determine whether this project is consistent with local needs, correct?
Correct.
To make that determination, because the developer has an enormous amount of risk, there may be lots of experts, there may be few, it depends on the size of it, but it's a really comprehensive hearing, correct?
Correct.
None of which would have to take place if the town is correct.
I disagree, Your Honor. And in Boothroyd, you also disagreed. And you concluded that the town must always engage in that deliberation, regardless of whether it's met one of the statutory minima.
You said a minute ago that, if I understood you correctly, that the standard before the HAC, whether or not the town has met the 10% quota, still requires HAC to consider the case because of the regional needs that are involved. But don't we have case law that suggests very strongly that once the 10% quota is met, the Housing Allowance Committee or Housing Approval Committee loses jurisdiction over the subject?
I would disagree with the terminology loses jurisdiction. I would agree that the Housing Appeals Committee at that point would lack authority to compel the issuance of the comprehensive permit. But the Housing Appeals Committee can always consider whether, in fact, the town has rightfully invoked one of the statutory minima.
Okay, if the Housing Approval Committee does conclude that the 10% has been met, that the quota has been met, can it do anything to the permit? Can it either require the issuance of a permit or change it?
It may not, Your Honor.
Okay, all
And
right.
I'd just like to ask, it's the Housing Appeals Committee.
Housing Appeals Committee.
Your point that we don't know much about this DMR, these DMR units in the town, is a good one. Because we need that fleshed out considerably, and we just don't have it.
Yes, Your Honor, and it was the ZBA's burden before the Housing Appeals Committee and is the ZBA's burden as the appellant before this court to provide a record demonstrating that this developmental center should be counted. There are all kinds of problems and questions that arise if something in the nature of a hospital, which the Department of Housing and Community Development has decided is more like a hospital, more like a prison, less like a community group home, is to be counted. Now, the number 300 has been bandied about. In the complaint that was dismissed by the Superior Court, the allegation was made that over 300 units exist. We don't know how many over 300. We don't know if that's counting residents who are there today.
This question may be off the wall, but would nursing homes count? I mean, suppose the town had 5 nursing homes and 90% of the patients were on Medicaid. Does all that count?
I don't believe it would, Your Honor.
I don't either.
Under the subsidized housing inventory and the points for eligibility, I do not believe it would. That would be more like a hospital, more like a prison. I hope that's not taken out of context.
Just use hospital.
Thank you.
Let's stick with hospitals.
But I will state that the question is, a question that arises is,
I
are we
don't think
looking...
low and moderate income housing is defined in the applicable federal or state statute covers nursing homes, does it?
I'm sorry, Your Honor?
I don't think low or moderate income housing, low or moderate income housing, as defined in the applicable federal or state statute, covers nursing homes.
I would not think it would, and I do not believe that the Wrentham Developmental Center is covered either, because the intent of the program is what's relevant under both Chapter 40B and the regulations, that is that a program subsidized to create affordable housing. The Wrentham Developmental Center, one of the 5 former state schools that remains in existence, was developed to provide programs for the mentally retarded. And I have to clarify the record here. The words mentally ill and mentally retarded have been interchanged. They should not be. This is a program run by the Department of Mental Retardation. And the questions arise. Some of these schools have been closed. There's a battle going on right now concerning whether the Fernal will be closed. If this is closed, then what happens? Developers have to go back and start from scratch for their programs to be, their comprehensive permit applications to be considered. If residents leave, if residents dies, many of them have been there for a very long time, then do we recalculate the number of residents who are there? The ZBA has not explained how this would work in practicality, and as the appeals court concluded...
But that's interesting, but you have a regulation that says that housing created for persons who are mentally ill or mentally retarded are low or moderate income housing. That's within the definition. And that includes all group home units for such persons in each community.
But one has to read that along with the language in the definition of Section 20 that states that anyhow it is only where such housing is subsidized by federal or state government under any program to assist in the construction of low or moderate income housing. And the regulation, Your Honor, is quoting, goes on to state that where group homes are reported by the Department of Mental Retardation to the Department of Housing and Community Development, then they are counted. In this case, the units in the Wrentham Developmental Center were not so reported.
Ms. Slice, your time is up, but let me ask you this. It's perfectly clear from many of the questions that have been posed to Council that one of the overriding concerns is how the statutory and regulatory framework will assist in expediting the construction of affordable housing. It is also clear that there are some ambiguities, perhaps not in the statute, but in the regulation about the whole thing is working at the present time. Have Council for the Housing Appeals Committee or Council for the Department considered what would be most advantageous in terms of stability and reliability and expedition?
I will say, Your Honor, that there are new regulations out for notice and comment right now that would address some of these issues more specifically. But currently, I will state that if the comprehensive permit that had to take place clearly under Section 20 had been done, we would have been done by now. We would have been able to go through judicial review, and I would dispute the conclusion that it is the position of the Housing Appeals Committee that is contributing to the delay here. I thank the Court for its time.
We'll take a short break.